Welcome back to 2A News Now, and I really do appreciate you taking your time tuning into my video. This falls under the category, you just can't make this shit up. A federal judge has ruled you have a right to keep and bear arms, but you don't have a right to obtain one. Yep, you heard it right. If we possess the right to keep and bear arms, then it stands to reason we must also have the right to acquire one. But according to a federal judge in Colorado, no such right exists. U.S. District Judge John L. Kane. And this shows you that we also need some type of term limits for federal judges as well. An 86-year-old appointee of Jimmy Carter back in 1977 made an eyebrow-raising decision in a case known as Rocky Mountain Gun Owners versus Polis, which challenges Colorado's newly enacted 3-day waiting period on all gun sales. Kane denied the group's request for an injunction that would have halted enforcement of the waiting period while the litigation continues, ruling the plain text of the Second Amendment only covers the right to keep and bear a firearm, not to purchase or acquire one for lawful purposes. So you have the right to possess a firearm, but not the right to obtain one? Judge Kane's reasoning would leave the door open for all kinds of restrictions on the acquisition of firearms. Hell, why not a 6 months waiting period? How about a $500 administration fee for every firearm purchased? Or mandating purchasers come up with a half-dozen character references before a gun can be sold. Taken to its extreme, Kane's position would leave open the possibility of a complete and total ban of gun sales. It's ridiculous to separate the right to obtain a firearm with the right to keep and bear it. But that's exactly what the judge did here. Judge Kane went on to say that even if commercial sales of firearms are protected by the Second Amendment's language, Colorado's waiting period is likely to withstand court scrutiny because there are no Guns R Us outlets. At the time the Second Amendment was ratified, it could take days, weeks, or even months for a would-be gun owner to acquire a firearm while they awaited for a shipment of muskets to be delivered to their nearest city or town. Of course, there was no law requiring people to wait before purchasing a firearm if one was readily available, nor were there any other prohibitions on private transfers of arms. If your neighbor had a fowling piece you wanted to purchase, you could walk or ride to his farm and make a trade or a cash transaction without possibility of punishment from the state. Judge Kane also said, though there weren't any statutes in the historical record that mirror Colorado's modern waiting period, there are some old laws that he believes are a close enough analog to allow the state's 3-day waiting period to pass muster. According to the Colorado legislature, the purpose of the waiting period is to help prevent impulsive acts of firearm violence, including homicides and suicides, according to the judge, because the ostensible reason for the waiting period is similar to the rationale on historical prohibitions against carrying while under the influence. Under that theory, virtually any gun control measure could be deemed as part of the historical tradition, so long that lawmakers contend that its purpose is to prevent impulsive acts of gun violence. If the majority in Bruin believe that opinion would put a stop to Second Amendment shenanigans in the lower courts, it should be clear to them by now that is most certainly not the case. We've seen judges declare that commonly owned firearms, like semi-automatic rifles, are not protected under the Second Amendment. Wide swaths of public spaces can be deemed sensitive and off-limits to lawful carry, and the right to keep and bear arms does not encompass the right to obtain arms. Each of these decisions is a gross misreading of Bruin, as well as a green light for fundamental infringement on our Second Amendment rights. But until SCOTUS intervenes, these abuses will continue. Like I said earlier in the video, this judge is 86 years old, and it just goes to show you we need some type of term limits for certain judges, especially federal judges, and of course in Congress. It's ridiculous that a judge can rule that you have a right to keep and bear arms, but that you don't have a right to obtain firearms. It's the perfect example of liberal logic. I would really like to hear your guys' thoughts about the judge's decision in the comment section down below. And I appreciate everybody's support with the channel and everybody's well wishes when I was in the hospital. And you guys are always crushing it by liking, sharing, and subscribing and hitting those post notifications. And I invite everybody back to see my next video.